Thank you for joining us today. I'm Catherine Brustowitz, and here with me today also is my esteemed colleague, David Gabor.
Thanks,
Today-
Catherine. Nice to see you, everybody.
Always a pleasure. So, as you see, the name of today's presentation is The Impact of the Circuit Court Split on Employer Liability for Third-Party Harassment. And today we're going to be discussing the standards of liability for employer negligence as it relates to sexual harassment. But first, we'll introduce you to the definitions of sexual harassment and hostile work environment. Then, we'll explain how the protections of Title VII extend to incidents of harassment against individuals in protected classes. We will review the rules on liability both before and after Bivens v. Zepp, which is the central case that we're going to be discussing today. And then we'll delve into what the impact of this case means for employers in the Sixth Circuit, for employers in multiple different states, and best practices for employers in other jurisdictions. Then we'll switch gears and give you some engaging hypotheticals. As a spoiler alert, these hypotheticals might have a Back to the Future backdrop. And to wrap up the webinar, we're going to discuss some concrete strategies for implementing best practices and adapting to the changes that Bivens has brought. I do want to mention, and you'll see in the upper right-hand corner of this slide, that if you run into any technical issues during the webinar, please send an email to webinars@wagnerlawgroup.com, and help will be on the way quickly. So, without further ado, David, I'd like to turn it over to you.
Thank you so much, Catherine. And again, welcome, everybody. We're glad that you were able to join us live or off of our website. So, hostile work environment is defined as a workplace permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the terms and conditions of the victim's employment. It creates an abusive working environment. The conduct needs to be unwanted and unwelcomed. The definition is consistent across various legal authorities and jurisdictions throughout the United States. So, to establish a hostile work environment claim, the employee must show that the harassment was unwelcomed or unwanted and is based on a protected characteristic, including gender, race, religion, ethnicity, national origin, disability, and age. It's sufficiently severe or pervasive that it alters the conditions of employment. And the liability often hinges on whether there is a tangible employment action or the availability of an affirmative defense, which we'll talk about more in a couple of minutes. The environment must be both objectively and subjectively hostile, meaning a reasonable person would find it hostile or abusive, and the victim must perceive it as such. We often look at the totality of the circumstances, including the frequency and severity of the conduct, whether it was physically threatening or humiliating, and whether it unreasonably interferes with work performance. The employer responsibility is to prevent the hostile work environment by taking reasonable measures to prevent and promptly address harassment or discrimination in the workplace. The duty applies to harassment based on protected characteristics such as as I said before, race, gender, national origin, religion, age, and disability. And employers may be held liable for harassment by supervisors or coworkers if they fail to take the appropriate steps. When it comes to supervisors, it often hinges on whether the harassment culminates in a tangible employment action and whether the employer can establish the affirmative defense. The available affirmative defense goes back to Farragher and Ellerth. Those are cases from, I think, 1998, where the Supreme Court threw a carrot at employers if they created harassment prevention policies, they trained the employees, there was a complaint process, and if the employee unreasonably fails to take advantage of the corrective opportunities. Now, if the harasser is not a supervisor, the employer is liable only if it is negligent in controlling working conditions, meaning the employer knew or should have known about the harassment and failed to take appropriate action. Similarly, the employer created an effective anti-harassment policy. They trained the employees, and again, the employee did not take advantage of it. So, Catherine, let's talk about third parties. Thank you very much.
You're
Before
welcome.
this Bivens case came down, an employer can be held liable for harassment of an employee by a third party, such as a customer, a client, a vendor, if the employer knew or should have known about the harassment and failed to take immediate and appropriate corrective action. The concept is that the employees have the right to work in an environment free from harassment. The standard is grounded in negligence and focuses on whether the employer took ordinary and reasonable steps to address and prevent the harassment from taking place, especially once it became aware of it. If the employer's inaction allows hostile work environments to persist, it is the same description as on the prior slide, an environment permeated with discriminatory intimidation, ridicule, or insult that is so severe or pervasive, it alters the terms and conditions of employment. Now, before I jump into talking about some of the different circuits, the concept is with a third party, especially a client. Imagine a person is working in a company, maybe they're in a sales role or a service role, and they've got to go to the client's place of business. And when they go there, they're subjected to this harassment. And oh, by the way, the client happens to be a major financial source for this business. That puts the employee in a horrible situation. So let's talk about some of the other circuits. In the Fourth Circuit, it held that an employer is liable if it knew or should have known of the harassment and failed to take prompt remedial action reasonably calculated to end the harassment. In the Ninth Circuit, in Galdemes versus Potter, it emphasized that an employer may be held liable if it ratifies or condones the harassment by failing to investigate and remedy it after learning of the conduct. In the Gardner CLC Pascagoula case, the Fifth Circuit highlighted that the focus of Title VII liability is on the employer's conduct and not the and the non-employee, can be the source of harassment if the employer failed to act upon the knowledge of the hostile work environment. Additionally, courts have noted that employers cannot adopt a see no evil, hear no evil strategy to avoid liability, as they are expected to take proactive measures to address it. That's the Freeman versus Dow Tile Corp case. The Equal Employment Opportunity Commission guidelines also support that standard, stating that employers may be responsible for the acts of non-employees if they fail to take immediate and appropriate corrective action upon becoming aware of the harassment. Back to you, Catherine.
Thanks, David. I think that that was a great explanation. It really does sound like this negligence-based test for liability is quite well accepted across most circuits and jurisdictions based on the case law that you just shared with us. So thank you very much for that. Now we're going to switch gears a little bit and talk about this Sixth Circuit case that maybe changed the liability standards, at least for the Sixth Circuit. In this particular case, the defendant Zepp is a motel that's located in the state of Michigan. The plaintiff is Miss Bivens, and she was an outside sales representative. And she alleged that she was sexually harassed by a customer of the motel, or a client of the motel. She alleged that when she stepped into the motel manager's office, he locked the door behind her and made unwanted, unwelcome sexual advances. She reported the incident to her supervisor, who then reassigned the Zepp account to a different sales representative. Now, the whole issue truly came to a head when the plaintiff was terminated as part of a reduction in force quite shortly thereafter. Miss Bivens sued the motel, alleging hostile work environment, retaliation, and discrimination under both Title VII and under Michigan law. The district court granted summary judgment in favor of Zepp, the motel, as to all of plaintiff's claims. She, of course, was not happy with that outcome, so she went ahead and appealed. And the Sixth Circuit panel actually ended up agreeing with the district court's ruling on summary judgment. The court held that an employer can only be held liable if they intended for the harassment to occur, either by desiring it or by being substantially certain that it would result from its actions. Now, this is a pretty serious deviation from the previous knew or should have known negligence standard that David just described and explained is used by the EEOC in their guidance and in most other circuits and courts. So what exactly does this mean? What it means is that employers in the Sixth Circuit can only be held directly liable if they were substantially certain that the harassment would happen. Now, I thought it was also interesting that the court stated that it was not bound by the EEOC guidelines on interpreting Title VII, as it must, quote unquote, independently interpret the statute. And in so doing, the court significantly narrowed employer liability for third-party harassment in the Sixth Circuit. Now, speaking of the Sixth Circuit, David, would you like to talk a little bit about the impact on employers in the Sixth Circuit?
Thank you, Catherine. Clearly, the threshold, as defined by the decision in Bivens, makes it much more difficult for an employee to bring a case under federal law saying that the employer failed to create a safe workplace when the harasser was a non-employee. But it's a lot more complicated than that. First of all, cases can be brought by employees alleging harassment in state court or federal court. The Sixth Circuit decision covers federal and not state law. So the four states that are in the Sixth Circuit, Kentucky, Michigan, Ohio, and Tennessee, have their own statutes and their own administrative guidance. So an employee can still sue an employer under state law. They don't have to sue under federal law. So the decision doesn't change the obligation employers have under state law. The ruling, does cover clearly what happens, if an employee brings a case against an employer under the federal law in those four circuits. And Catherine and I are going to go back and forth on this slide and the next slide because it gets kind of interesting when you've got an employee who works, let's say, in Michigan, and the employer is outside of the Sixth Circuit, or vice versa. You have an employee who is outside the Sixth Circuit, but the employer is in. And Catherine's going to touch on that in a moment. And then we're going to hit those points in the hypothetical. But I think it's really important. And those of you who've attended other webinars that Catherine and I have presented is we look at these cases from a lens that's a legal lens, but also a best practice lens. So if you are an employer, and like I said a couple of minutes ago, and you've got an employee who's working with a huge client, and the client happens to be a pig and harasses the employee, and your response to the employee brings it to your attention is to reassign the employee to another account, probably costing the employee a lot of revenue if they're in some type of a profit share or a bonus program, commission program, where you bury the head in the sand because you don't want to, rock the boat. This is a huge client or customer that you're dealing with. But if you take that kind of approach, putting aside liability, you're doing the wrong thing. Your responsibility as an employer is to do your level best to create an environment free from harassment. So that's something to keep in mind. A couple of other things. The fact that a circuit court returned a decision in this case does not mean that's the law of the land. The case has not gone to the Supreme Court. It may or may not end up at the Supreme Court. And if there's a writ of certiorari filed, the court may not accept the case. So it's not the law of the country, and it's not finding it final and binding in any respect. Last point is don't let your guard down. You have the responsibility that we described under state law. You've got a responsibility to create a workplace that's, safe for your employees to the best of your ability. You're never a guarantor is a safe workplace, but you've got to make a reasonable effort to do so. Failure to do so, in addition to liability, will result in unwanted turnover, morale issues, and a dissatisfied workplace. So, Catherine, do you have any thoughts on that before you jump on to the multi-state employers?
Yeah, no, I think that everything that you said is strong and on point. I especially feel strongly about the last point on this slide. Don't let your guard down. We're going to talk a little bit more in depth later on in the program about, the negative impacts on productivity and morale loss and really the tangible impact that not doing the right thing as the employer has on employees. So I appreciate the fact that you brought up sort of the moral obligation that employers really need to do their level best in trying to create a workplace that is free from hostility and discrimination and harassment. So thank you very much. I think you did a fine job there. So what I want to talk about now is multi-state employers. For multi-state employers, it really is crucial to maintain your robust anti-harassment policies, as well as training. And those policies and training should satisfy the broader negligence standard. As we've mentioned, other circuits will continue to apply that negligence standard. Just because it was narrowed in the Sixth Circuit doesn't mean that it was narrowed for the others. So if you are an employer who is operating in multiple different states and jurisdictions, the safest bet is to make sure that your anti-harassment policies and that your training satisfy the negligence standard. And it can be a little bit tricky because multi-jurisdictional employers have to navigate these two conflicting standards. So, what I would advise my clients to do is that if you are, in fact, an employer that operates in multiple jurisdictions, you need to tread carefully. While the Sixth Circuit has now embraced an intent-based test, other circuits still follow the EEOC's negligence-based standard. And so what that means is that liability may attach if an employer merely knew or should have known about an alleged harassment incident and then failed to act. So to ensure consistency and to minimize your risk, employers should apply a national best practices approach and treat all harassment, regardless of the source, with the same degree of urgency and seriousness, even if you are operating in jurisdictions or if you have employees working in jurisdictions where the legal standard is more employer friendly. We're going to talk a little bit more about implementing best practices shortly, so we will go into a bit more detail then. But before we get into that,
Hey, Catherine, can I jump in for a second?
yes, please do.
Okay, thanks. So when we talk about multi-state employers, I think the image that first comes to mind is that you've got an office in, let's say, Massachusetts, Chicago, St. Louis, California and New Mexico, and you're working those jurisdictions. But one of the impacts of the pandemic that we have seen in our practice again and again and again is when we have remote employees. You could have an office in Boston, but employees working in upstate New York, in Connecticut, in Vermont. So what oftentimes happens is that remote employee is entitled to the full protection of the laws where they work. So even though you may be a Massachusetts company, you've got to abide by laws that are, let's say, in Connecticut, Vermont, or upstate New York. And that becomes the responsibility of the employer. And the same is going to apply if maybe your office is in Kentucky, but the employee is working in another state, let's say South Carolina or North Carolina, where they are outside of the Sixth Circuit. So I just wanted to add that one point. But thanks, Catherine.
Thank you, David. That was a good reminder to our listeners and spot on. So now that we have covered, a bit of just practical tips with respect to multiple state employers, we would now like to introduce some hypothetical scenarios. And these hypotheticals are going to help to reinforce the various standards of liability, and just give us a little bit more of a hands-on approach to really understanding this. Okay. So, Hill Valley Auto Company, HVAC, is known for its cutting-edge technology. This cutting-edge technology includes hoverboards and its time machine. Doc Brown is the owner of HVAC. HVAC has entered into an agreement with Biffaroni Carting to dispose of waste. Biff's uncle owns Biffaroni. George is the COO, and Strickland is a principal. It's important to note that HVAC is located in the Sixth Circuit. Biff hits on Lorraine, who is an employee of HVAC. So, David, in this scenario, would you say that HVAC is responsible for Biff's actions?
Well, I remember something from the first day of law school. It depends.
Ah, yes, the typical attorney response to almost any question.
I had to throw it out there. But in this scenario, uh, under federal law in the Sixth Circuit, probably not. But we would have to drill down further to learn about, well, did Lorraine make a complaint? Was anyone in a supervisory position present when Biff hit on her? Uh, did it happen one time? Did it happen more than one time? I mean, if it's a single incident and he asked her on a date, is it harassment? There's a lot of information that we would need to digest on that one. Now, keep in mind, under state law, it's easier to establish liability because state law probably would still apply the negligence standard that Catherine and I have both spoken about. So in the sense of a single act and the employer is not aware of it under federal law, probably there is no liability for the employer. If it happened one time and it was just asking Lorraine to go on a date or to play on their hoverboards, and the employer was aware of it but did nothing, still probably no liability because that doesn't rise to the level of harassment. But if, again, it was in the presence of someone in a leadership position, it's possible to have liability under federal law. Catherine, do you agree with me or do you want to push back on that?
I do agree with you, but I was just wondering. We all know that Biff is a rather unsavory character. And in this situation, does it make any difference that Biff's uncle owns Biffaroni?
I don't see where it makes a difference, but I do have to commend you, Catherine, for putting Biff in a waste management business, given what happens to him in all three movies.
Well, it seemed only appropriate.
Uh,
All right. Well, thank you for answering my question with respect to the first scenario. It makes good sense. I liked your response. To put a different spin on this, David, what if Lorraine was working in the state of Michigan, but HVAC, the company, is located in the state of Illinois?
that gets interesting because under Illinois law, uh, the company can be liable, you know, if it doesn't take the appropriate steps under a negligence theory to create a workplace that's safe for Lorraine, when the bad actor is a non-employee, it's a third party. But since she is in Michigan, are her rights limited to the protection afforded under Michigan's federal law? This is not clear from the decision of Bivens, but my guess would be that under Michigan law, federal law, she's out of luck. But under state law, there's still liability. What do you think?
Yeah, I absolutely agree with you. And just to sort of add to your point, I think that it's a very good idea for employers to make sure that they're aware of the state-specific harassment laws in each and every state in which they have an employee working, and in each and every state in which they're actually operating as a company, because the laws really do vary tremendously from state to state. And so it would behoove employers to make sure that they're aware and up to date on those laws. And if you're ever in doubt or you need help, there's absolutely no shame in reaching out to an HR consultant or an employment attorney because some of these employment laws can get a little bit murky. And when you are, a multi-state employer, the complexity of this sort of patchwork or quilt work of various states can be a bit overwhelming. And as a business owner, you're going to want to concentrate on what you know best and what you do best, and that is your business. So I
Uh,
did just want to make that point that reach out if you need help. Um,
Great
there
call.
are, go ahead.
I'm sorry, that's a great call out. Conversely, though, if Lorraine is in Chicago and HVAC is located in Michigan, then, as we alluded to earlier, she would be entitled to the rights and protections under the Illinois law. And in that situation, like, would be much more likely to find that this is could be a violation of the laws in Illinois in that situation. Again, if you can show that there was enough interaction with Spiff to create a hostile work environment, severe or pervasive, alter the terms and conditions of her employment. Um, just wanted to add that in.
Yeah, great point. Great point. Now, let's say that Doc Brown, who's the owner of HVAC, let's say that he time travels and he saw how Biff harassed Lorraine. I'm sure he would have exclaimed, "Great Scott!" Anyway, I do love that flux capacitor. Hmm. So, David, in your opinion, would you say that Doc Brown, having come back through time, witnessed Biff harassing Lorraine, does that have any impact on your opinion with respect to HVAC being responsible for Biff's actions?
Oh gosh, I love this question. I'm a nerd and I love that movie. I know it came out a long time ago, but I still watch it, whenever I can. So Doc Brown travels ahead. I'm sorry, travels ahead, sees what's happened, travels back. He now has knowledge. He knows that Biff harassed Lorraine. He's aware of it, and he's in a leadership position with the business, high level leadership position. So now you have actual knowledge. So in that setting, I say yes, yes. Um, Now HVAC is obligated to take appropriate steps to address it, prompt remedial steps. However, Catherine, I've got to ask you, have you ever gone into court and argued that your client or the adversary time travels.
I can't say that I've ever successfully used that argument in court, no.
It would be on the front page of the paper for sure.
I also might lose my practice to license to my license to practice law if I, claimed time travel. Um, David, would you say that just because in this situation Doc Brown had knowledge of the harassment, does that establish that he intended for the harassment to occur? How do we play that out?
That's a good question. I think we can go as substantially certain
Hmm.
that the
Yes, I think
harassment
you're
would
right. And then
result.
it all hinges upon what actions he takes thereafter in order to try to address the harassment and not have it occur again, correct?
Yeah, I would think so. And
Yeah.
there are a whole lot of issues that could arise in the future that it's hard to read from the opinion, how courts will be expected to deal with it. So, for example, if I know that someone harassed Lorraine and I don't take any steps,
Hmm.
did I ratify the conduct?
Hmm.
And would ratification, amount to or give rise to intent for the conduct to continue?
Yeah, I think there's certainly a strong argument for that. Yeah,
That's
I agree.
I mean, I've used that argument in court several times where by allowing something to happen, you've ratified it.
Hmm.
But I haven't
Hmm.
done that in the Sixth Circuit.
Fair enough. Okay, so in that situation, it would behoove Doc Brown to act accordingly and make sure that Biff stops harassing Lorraine. Great Scott. All right. I think we've got about two more slight changes to the scenarios, David. So forgive me, but I'm gonna hit you with a couple more grilling questions here. Let's say that Lorraine complains to George, and just by way of reminder, George is the COO. She complains to George about Biff. Now, George has a problem with confrontations, and he does nothing. He completely fails to act upon Lorraine's complaint. What do you think?
Under state law, I think there's a liability. Under federal law, um, that would be tough because you go back to, is it ratified in this situation? George, before he throws the punch at the dance, he was, with all due respect, he was a very meek, mild-mannered person who didn't have the courage to do things. Um,
Mhm.
but I do think, if he's in a leadership position like the chief operating officer, he has to act. So I could see arguing HVAC is responsible in that sense because George knew and she reached out to him, she complained to him, and he did nothing. So I'd be comfortable arguing, Lorraine's case in that scenario. How about you? Would you argue for her case?
Yeah, I tend to agree with you. Even if George being in a leadership position, we'll say he's shy, we'll say that he's meek, he personally could have failed to act, but he also could have gone ahead and just spoken to HR or, escalated Lorraine's complaints. So I think that, HVAC would be liable in this situation, and George could have pretty easily skirted around that liability if he had just raised it, to the appropriate channels. Because in doing nothing, that is sort of, what you said earlier. It's the stick your head in the sand approach. And that can be really dangerous for employers. Um, so yes, I am in agreement with your conclusion on that particular scenario as well. Did you have any other thoughts or anything that you wanted to add to that one before I hit you with another question?
Well, I would say one thing, and this kind of goes back to training. I know you're going to touch on that in the next slide. But it's so important that managers understand and leadership understands their responsibility when an employee reports a concern or an issue to them. And
Hmm.
this goes way beyond just what's going on in federal law in the Sixth Circuit. Managers have to have those tough conversations, take those tough stands. It's not a good place for an amiable.
I agree. And I also, would be remiss if I didn't mention that training that is so imperative for managers, that training should happen in advance. They should be prepared before they're ever confronted with their first complaint of harassment. They need to know, what the protocols and procedures are. They need to know how they should respond to the employee who's reporting it. They need to know how to escalate this up the chain of command. They have to know how to perform investigations. And it's critical to have your frontline supervisors and managers be trained ahead of time so that they're not thrown any curveballs and perhaps respond incorrectly. Um, so great. Thank you for bringing that up, David. I think that was a really helpful reminder. I think that at this juncture, we are going to address the last hypothetical scenario. In this scenario, Lorraine makes a formal complaint to Strickland, and Strickland is the principal. Strickland goes ahead and fires Lorraine. Uh, Smells like retaliation to me, but David, what are your thoughts on that?
Yeah. In that scenario, when when there's a question of harassment and then the employer terminates the employee, that's an affirmative action by the employer. Yes, retaliation is the first thing that comes to mind. And as we talked about earlier, it could be a demotion, a suspension, reassignment to an undesirable position, or termination of employment. Any of those types of things in that situation does amount to potentially a wrongful termination claim. And, you know, to get retaliation, you put the employer on notice of harassment. If it's based on one of the seven deadly sins, gender, race, religion, ethnicity, national origin, age, or disability, and that's the basis for the complaint. The employer knows of it because the complaint was made to a person in an executive position, and within close temporal proximity, there's an adverse employment action, termination. You've got a retaliation case.
Mm-hmm. And what if Lorraine makes the formal complaint to Strickland, the principal, and then Strickland sits on it for a little while, doesn't escalate it to HR. Let's say maybe 3 months go by, and then he decides to fire Lorraine. How does that impact the strength of any claims that Lorraine might have?
So, assuming there was one complaint by Lorraine and only one complaint, and that's to Strickland,
Yes.
and then she doesn't do anything else about it for 3 months, and then Lorraine gets fired, then I think in that scenario, Lorraine would probably have to demonstrate that but for her complaint of harassment, Strickland would not have fired her. So
Excellent.
she'd have to show something more than just she had that one complaint in that situation.
Mm-hmm.
And
So
Strickland was going to probably respond by saying, Lorraine, you're a slacker. Your brother was a slacker. Your father was a slacker. You never amount to anything in Hill Valley.
where
So
have I heard that before?
I don't know.
Well, that's great. I think that you've really hit the nail on the head there. That explains, just the importance or significance of the temporal proximity, and that but for argument. So thank you for that. To our listeners, I hope that these scenarios were a little bit of fun for you. We thought that this might be a nice way to engage in the legal side of things through a little bit of levity and good humor. So thank you for bearing with us while we ran through these silly hypotheticals. So now I would like to take the opportunity to discuss some strategies for implementing best practices. Some of this may sound a little bit repetitive because we have given some of these as examples in previous slides, but they really are important. And these are strong strategies that you should take away from this program and bring back to your companies. Employers are really encouraged to take proactive measures to prevent harassment. We've made that clear. And some ways that you can do that is by implementing anti-harassment policies. As we just discussed, providing hands-on training. And that training, again, it's really important to train in advance because we don't want our employees to be blindsided, especially not if they are in management positions and if they have, um, employees coming to them. They want to be able to know how they ought to respond. And then also establishing effective complaint procedures. There's a secondary note with respect to the effective complaint procedures. It's important for the employer to make sure that employees are aware of what that complaint procedure is. So making sure that it's readily available and accessible, employees know how to find it, they know what to do if something occurs that they feel amounts to harassment. So those steps alone can really help to mitigate liability. But over and above that, it also helps to demonstrate the employer's commitment to maintaining a harassment-free workplace. So I do implore you as an employer to please continue to investigate any reports thoroughly. Do train your managers. And one thing that we haven't mentioned yet, and I'm usually constantly harping about documentation, but it's very important to document all of the actions that have been taken in response to any harassment complaints, because that will help to demonstrate your compliance, and those documents may end up being exonerating down the line, should there be any type of a lawsuit that hits your desk. Don't forget, the heightened standard does not eliminate employer responsibility. I really can't emphasize this point enough. And just to circle back to something that David had mentioned, while Bivens adopts a narrower view of liability, it certainly does not give employers a free pass. This new intent-based standard for the Sixth Circuit is indeed harder for plaintiffs to meet, but employers should still take all harassment complaints seriously. You should conduct thorough investigations of those complaints and then take appropriate and reasonable corrective action. So we advise our clients to continue to investigate, to continue to train managers properly, and again, to document all steps that were taken in response to complaints. These are some of the best practices that will help to mitigate your exposure to potential liability. And failing to take these steps can actually expose employers to liability under other legal theories or under broader state law protections. Don't forget, most states do have their own anti-discrimination and anti-harassment statutes, and those oftentimes provide broader and stronger protections with lower thresholds for liability than those that are provided by Title VII of the Civil Rights Act of 1964. And David had alluded to sort of the moral obligation of employers to do the right thing. And hand in hand with that, I think that over and above the legal exposure, ignoring harassment in the workplace can result in pretty significant reputational harm to the employer. And it can very negatively impact overall employee morale and engagement. It can decrease employee productivity, uh, employee loyalty to the company, and ultimately it may lead to higher employee turnover, which ends up being quite costly to the employer. When you lose an employee, especially a great employee, it's you feel the hurt of that because you then have to spend the time and the money of recruiting a replacement and then training that replacement. So I think that there would be a strong return on investment if employers remained truly invested in keeping the workplace free from harassment. If they hear about complaints of harassment, truly doing a thorough investigation and taking the appropriate steps to follow up and not sticking your head in the sand. And yeah, the last point that we have here on this particular slide is the suggestion that you lead by example. Lead by your actions to reinforce that you do want your place of work to be a best place to work, a safe place to work, and a place where you don't feel like you're being harassed. So, with that said, David, did you have anything else that you wanted to add to strategies for implementing best practices or anything else that you think our webinar attendees should be made aware of with respect to the harassment or to training or responses,
Absolutely,
liability?
Catherine. You nailed it, and we are also at the end of our time.
Perfect.
So good job.
Oh, good job to you. The last thing that I did want to mention is, employers and companies may have the need for legal counsel or advice in matters that go beyond the scope of human resources and employment law. So we just wanted to take this short opportunity to ensure that you know about the other practice areas that the Wagner Law Group maintains, just in case you need assistance with, ERISA, employee benefits, investment management, restructuring, or bankruptcy, for example. So keep that in mind. If you need help, we're here to help you in employment law, labor, and human resources, but in other realms of the law as well. And with that, I would like to thank you all for your attendance. If you have any questions that we did not address during our program, feel free to reach out to us either by email or by phone, and we would be more than happy to get back to you with a response.
Absolutely. And happy holidays to all of you. Thank you so much for attending.
Thank you.